Hi, hello. Very good evening. We back today. Last week, everyone know in Texas is winter storm. That was awesome experience, and also most of the people have a lot of issues. No one prepared for winter storm. Anyway, we are good and safe, and we back today for live. As usual, we today we brought good news and we brought new important and interesting points. The new administration is started to reform the immigration policies. Today we can discuss new policies and Lucas have the very good news for H1 holders who want to travel outside and come back. And following, we can check with 485 the status and the new H1 process cap 2022. And if anyone have the questions, we can take a question and clarify for you. Just we requested to you can call to conference number, or maybe you can post in Facebook and YouTube. We can address your question and topic. Let's welcome Lucas. Good evening, Lucas. How are you?
Good evening, Venkat. Doing well. It's much warmer today than it was this time last week.
Yeah, I hear Dallas is worst time last week. No water, no power. I think you were safe and you're safe.
Yeah, we experienced one day without electricity, but overall we were blessed to have power the rest of the time and always had water. So there's been a lot of people here in Texas, going through some hardships here recently. So I'm glad the weather's back to normal.
Okay. Yeah, let's come to today's immigration show. Give me what is important. What is the good news first of all? What is the good news?
Well, good news today. While we were, just maybe 2 hours ago, we learned that President Biden has gone ahead and rescinded the presidential proclamation limiting certain immigrants and non-immigrants from entering the United States. It's introduced by the Trump administration. So, as we know, there's been quite a few people that have been stranded abroad, not being able to get a visa stamp and return to the United States unless they were, a member of an exempt group, whether it be a member of a lawsuit or if you're an essential worker or someone tied with the COVID-19 relief in some way. So it's very good news. We're hopefully going to be able to get back to some type of normal processing of people traveling, to and from the United States. Again, you want to check with Department of State if you're abroad right now.
Muted.
Or if you're planning on traveling back home, you want to make sure that you have followed the most recent protocols as far as having a negative COVID-19 test. And you can, for the United States, you can look at Department of State website to determine what the most recent protocols are. And also you need to check with, if you're traveling abroad, your country of origin, where you're traveling to, and what their protocols might be.
Okay. This proclamation is immediate effect, or is any in future date to start implementation?
It should be an immediate effect. Now, I have been working with quite a few people who've booked slots over the past month to 2 months, and there was a court case that resulted in a court order mandating that if a petitioner or their employees were a member of this organization, which was the U.S. Chamber of Commerce, that the Department of State would have to go ahead and issue the stamp for the employee to return to the United States. So now, some of those slots were already being booked for those exceptions, and now with the proclamation lifted, I mean, whoever's going for stamping from this point forward, or whoever is booking a slot from this point forward, there should not be any hindrance on receiving a H-1B visa stamp, a J-1 stamp, or any other stamp that was issued as part of that proclamation.
Okay. Lucas, now most of the H1 holders are seeking for visa appointments, and what your suggestion? Would you recommend go to the India or Indian-based H1 India, or we can go for Mexican or Canada for H1 visa stamping?
I think, this is whenever this question is raised to me here, from any of my clients or anyone who calls or emails, I always say, first and foremost, let's consider health and safety. Right now, with the global pandemic, it's probably in everyone's best interest. If there's not an emergency to travel to get stamped, it's probably best to wait until, there's more progress made where restrictions are lifted. We don't want to travel abroad, even if it's to Canada or Mexico, and have some, mitigating event that limits your ability to return to the States or impacts your safety, or that's first and foremost. So if there is an emergency, most people who have been traveling have traveled back home because maybe there's a family issue or a family emergency that would require them to return home. So obviously, to answer your question, probably the best way to get stamped would be your country of origin. And I would highly recommend, people booking appointments just to have the stamp. At this point, I would strongly urge those people just to wait. There's really not, any impending need to have that done just to have a stamp. So I would postpone the travels until, things get back to normal here.
Okay. So we can discuss about Biden administration new immigration policies. Last week, the two senators are bring to House new bill bring to House. Do you know more information, preliminary information? We can discuss the new policy section by section, just to give me the overall idea about the bill and who. You give me the brief information on bill. Later, we can discuss section by section.
Sorry. I think what we want to address here is there's nothing really new in this bill that should catch anyone off guard from what you and I have been discussing for 4 or 5 months now. You and I both in detail expressed, the scenarios, what would happen if, President Biden was elected, if the Democrats maintain control of the House, if the Democrats maintain control of the Senate or obtained control. And we were saying over the past few months to say, if all these events happen, we're going to be looking at comprehensive immigration reform. And this is the first step to comprehensive immigration reform. This is the plan that, you and I have speculated about, that we've detailed from, talking points of other organizations from AILA, which is American Immigration Lawyers Association, or other maybe nonprofit entities who are immigration advocates, who've, suggested, certain concepts of, things we've discussed, such as family unity, issues with children aging out, EB backlogs, and certain other issues, maybe also impacting dreamers, what the plan is for, people who we refer to as a dreamer. Sorry. Can you see me?
Yes.
Sorry about that. Someone tried calling. So, it's very exciting. Now, what happened this last week? We had an issue where, we have one member of the House and one member of the Senate advancing these bills and introducing them. So this is very good news. Obviously, the most important thing we have right now, number one on the agenda, is probably the COVID-19 relief package. I think we're really close to having that, finalized and completed, so we can move forward with the next agenda. The next piece of agenda being comprehensive immigration reform. So we're really close to seeing key changes being made. Number one. Number two, if these changes are made, and as soon as everything's debated, voted on, everything goes to committee, so on and so forth, as soon as this is passed into law, we can expect these changes to actually be functional 180 days or 6 months after President Biden signs this into law. So it's very encouraging. We're really, really on the cusp of positive change that can impact a lot of people, especially pretty much almost everyone watching our show right now. You can pretty much guarantee on seeing change within this next year. So, if you want, we can take a few points of what was included in this bill and maybe discuss one by one.
Yeah. Before discussion, these sections, I would like to check with you. The last year, we know the bill, HR 1044 and S386 bills got approved in both the Senate and House, but unfortunately, due to the different versions, did not get through last minute. What is this bill situation in future? What do you think any two version of bills will generated from each Senate and House, or how we can, it means has a H1 holder, how we can expect this bill be approved or not?
Well, so I think the bill is going to be approved. If I were to bet money, I would bet heavily in favor of it being approved. Now, here's the caveat. What is going to be approved? What part of the bill or what parts that we have in front of us are still going to be there when we cross the finish line? So there's a lot of red pins and negotiations and edits and things like this that are going to be done. Maybe there's things that can be added that aren't currently in this, but this is a well thought out bill that has been pretty much been all these points have been discussed over many years, and it was some form or fashion this has to occur. Now, does it mean that everything in this bill is going to have to be included? Obviously not. It's not possible. Even if the Democrats had complete control to override any Republican objections to this bill, it's still, there's going to be, minor changes along the way. What I can tell you is the key thing that's included with this is positive impacts for a lot of people who are from India and are part of this immigration backlog for EB 2 and 3 immigrant visas. So, that is one issue that's addressed, that those two bills that you brought up in the beginning also were addressing. Now, this is going to go about it in a little bit of a different way and a different timing of it, but it's still a positive move forward as far as addressing per country cap quotas, reissuing unused visas from other countries or other resources, making them available for people who otherwise qualify, and are pending adjudication due to a backlog.
Okay. I think this year we have the good news for all immigrants. Maybe most of the policies might be approved. So let's come to, we can discuss the new immigration policies section by section. Lucas, the first section is section 3101, the recapture of immigrant visas lost to bureaucratic delays. So
Right.
Can you explain what is the recapture of immigration visas?
So what we're focusing on here is, if there's any delay in processing, where what we want to do is look at to see to make sure that, like we said on many shows, like the main concept of our immigration system, a key point is family unity. We don't want kids aging out. We don't want people to lose opportunities because of delays in processing. We don't want retrogression to occur. You know, we've had a lot of people, especially from India with employment-based background, where they'll be kind of stuck in a limbo for 2 or 3 years where they filed for adjustment of status, yet and the visa is available for 1 month or something, and then the next visa bulletin comes out and the dates retrogress. So we want to make sure that once a process starts, that we can timely finish that process, and we also don't want people to maybe miss opportunities because of administrative processing of that visa. So that's some of the key talking points there, and with part of this is in this proposal, we want to make sure we address to keep the backlog from growing more. You know, a key point that you and I discussed, Venkat, maybe 3 or 4 months ago is, hey, you know, right now an average family, you know, you have a principal H1B visa holder, you have their spouse, and maybe a kid. So that's 3 people. If you go and adjust your status, okay, that's using 3 visas. Common sense would tell you that we would want to have the H1B visa holder to go ahead and be counted as 1, and then his derivative family members not be counted against the available visas there. So it's 1 for 1, which means if we're looking at actual I-140s and not, you know, the principal immigrant and then all their family members. So that would help alleviate a lot of stress immediately from this backlog. It would help move things very quickly. And going back to what I was saying is a key component to our immigration system here in the United States is we always want family unity. We don't want people aging out, younger children who become adults. We don't want them to age out. That's also in here as a provision. We want to make sure that families stay together, that, you know, a family when you immigrate to the United States, that you're able to have your family and security and knowledge, knowing that you can be together if you choose to do so, that you're not forced to go back home or anything else.
Okay. Lucas, actually, we are discussing about the immigrant visas, recapturing immigrant visas. Here, I see is in the bill, it's saying that employment-based green card number, it means unused employment-based green card numbers from fiscal year 1992 to 2020. Let's say, do you have any additional information about this? How many visas can we get by this period, unused visas? Do you have any statistics?
I don't have off the top of my head the statistics for that, but what you're referencing is the key point here is that United States Congress has the authority to issue visas. The president, USCIS, any other regulatory agency doesn't have the authority to issue a green card or a visa without authorization from Congress. And so what we want to look at is whenever we have these in the past, maybe certain countries haven't used all the visas up, maybe diversity visas, not all the diversity visas were used, things like this. Then we can reallocate those unused visas for future applications. So it's almost like, if you can imagine, if every year it's only 100, you know, Congress is the only, you know, authority that can issue immigrant visas. So it's a matter of, you know, each year there's only so many allotted. So now what they're saying is Congress in this year to this year allotted this many visas and X amount were unused. Okay, so they're still here like in a piggy bank. We're just going to reapply it and spend them currently to help alleviate this backlog, if that makes sense.
Okay. Let's say if Congress is issuing, maybe USC is issuing unused employment green card from 1990 to 2020, they can utilize only the per country quota, or maybe they can use...
Well, that's a good point. I think here also within this bill that's proposed is to ease the restrictions on per country quota. So I think, and these are some of the points. I don't want to get too much into the details of what this means, because a lot of these details can change. And like I said, you and I have discussed in the past, if some of these the points in this bill don't make it past committee, or don't make it through the debate, or people don't want to vote through and approve, there's always other ways going about fixing this problem. You know, like I said, at the end of the day, Congress can also, if this doesn't work, Congress can say for fiscal year 2022, 2023, 2024, we're going to issue extra 100,000 visas to alleviate the backlog. So this is probably one of the more efficient ways of fixing the backlog, but there's other ways to do so. So in a grand scheme, in a generic way of looking at this, this is step one. If step one doesn't work, we can go to step two, step three, so on and so forth. Again, I want to stress there's a lot of other issues that were brought up in this bill, and I want to tell everyone at home, that the whole purpose of this, and I think the positive note for employment based, is to say, look, United States for the past I think 5 or 6 years has had a declining birth rate, which means fewer and fewer people are added to our population in the United States each year of native-born citizens, and we have a large portion of our population which are now retiring or aging out of the economy. So how do we make sure we stay a world leader and keep producing our economy at the top, as a world leader at the top level? And to answer that question, we need to have an increase in our population. And when we increase the population, one of the key factors is how do we want to increase it? Well, we probably want to increase it, from people who are high skilled, college degrees, things like this, to help contribute to the economy more. So that's something that's been discussed a lot in the news. It's been discussed a lot within each party. That's something that's needed. So having this information in here, I think to go back, and I know I'm kind of veering off point, but to go back to it, I think we want to take care, especially with everyone that's in this, taken care of within this bill. We also want to take care of any employment-based backlogs, because we want to make coming to America more a feasible process. We don't want families to be torn apart. We don't want one bad H1B decision, ruining someone's professional career after they spent 10 years here. We want to go ahead and make sure if people have the option to get a green card or become a citizen, that's available to them.
Okay. Lucas, here one section 3103, this is adjustment of family sponsor for country limit. So per country green card visa cap for family and employment based immigrants from current 7% to 7% limit to 20% of the worldwide total. How this 20% is a good number to increase, but how many visas will allocated for country?
Well, that's what we were saying a minute ago. We still have to wait and see. We don't want to get into too much of the details of what this is, because I can guarantee it's going to change. The small factors with this. What we're looking to do is to find a solution to alleviate the backlog at the moment. And what are the key principles to alleviate the backlog? We can, increase the per country quota, but there's other tools in here. Even if that's not done, and there's issues hanging up about that, what do we do for family unity? And I think that's the most positive issues that have come up in this. We have provisions in this where children will not age out. Okay, I talk to people every day where they have a son or daughter who's, attending college, and we're transferring from H4 maybe to F1, and how that impacts if, now the I-140 is current and dad had downgraded his I-140 so the family could adjust, but then obviously, some of the family is going to age out and not going to have that opportunity. So that puts a lot of strain on what we can do to keep a family together. And these provisions are the key provisions we should look at and be happy that they're included, because I think that once they're really in here, those are the details that really aren't going to change much. The minor details for how fast the quota is going to move, as far as if it's 15%, 20%, 7%, whatever the final number is, at least everything's moving faster. That's the most important point.
Okay. Lucas, here, Section 3404, increase the immigrant visas for the other workers. What does it mean, other workers, apart from the immigrant employment-based workers?
Well, so you have to look at it also as we have skilled workers, we have people from other countries. So when we talk about employment-based, I know, the biggest population that's been impacted by visa backlogs is mostly people from India and China. And what can we do to alleviate that for these groups? And most of the people from India, are computer science background, professionals in that sense, and do certain, have certain education, do certain jobs here in the United States. So there's other people from other countries that might have skilled labor or might have other, value that might not be the same type as what we're discussing. So we want to make sure we encourage all types of labor, not just, certain specific skill sets. We don't want to only allow, maybe nurses or doctors and disparage against computer science or computer programmers or, people with that background. So we want to make sure it's an even allocation.
Okay. So here I would like to discuss about flexible adjustment to employment-based immigrant visa program. So do you have any information about flexible adjustment, employment-based? Can you share if you have?
Which part are you referring to?
3405. Section 3405.
Okay, yes. So what we're talking about here is, the process of going from maybe a student to, green card, and bypassing certain employment-based, requirements like we have now, where you would technically want to be in H1 status, then go ahead and file I-140 and wait for the visa to become available. This right here is actually really positive. It's looking at, people who have high-end degrees like PhDs in STEM to go ahead and do self-petition for themselves. We also, you said 3105?
3405.
So again, flexible adjustments to employment-based immigrant visa program. Basically, that's going to help address the per country cap to help make sure everything's balanced, make sure, we're bringing in, certain people to help the economy that's identified as needed. There's also things in here that talk about, H4. And part of this bill also has a large part of regulation protecting the workforce, making sure that, there's a little bit more oversight, I think, from the Department of Labor, things like this, to make sure that, we find any issues, that might impact both Americans and other non-immigrant workers. And again, like I was saying, what we want to do is look at the big picture right now. We don't want to get too much caught in the details of piece by piece, because those details are probably going to change. And what we want to look at is to look at the overall path here of what we lined out for reform. So part of the path, obviously, as we said, was for dreamers, people who came here without status, people who, after going to school or working for a certain period of time, can go from a certain the status to legal permanent resident and the citizen. Then we have also, what problems, how can we mitigate the issues of people wanting to come here and seek asylum from Central America? Why is everything so bad? And how can the United States help fix that and deter, corrupt governments or gangs or whatever from continuing to impact the population there? And then, obviously it's discussing also about family values, unification, and then part of the point, like what we just discussed, is protecting workers from exploitation. So there is a sense, and I think everyone in H1B status knows this, there's if you're not able to finalize the process and adjust your status, you're somewhat stuck in a indentured servitude where you're not free to really move from one job to another, or fully embrace your career, maybe become an entrepreneur. You're kind of pigeoned into a certain role or a place. And we want to make sure that if someone is here on H1B working in a certain or other non-immigrant status, that they're not exploited. So all these parts of the bill are very important. These are all major key points that have been brought up. And, like I just said, not all these points are going to come through at the end. And the processes, procedures, things like this the details are going to obviously change going from point A to point B, getting this passed into law.
Okay. So by all this section, do you think all section will be approved, or the Senate or House will get more question, and maybe they can raise the maybe they can raise, or they can change these sections as per initial draft?
Well, I'll give you a good analogy. It's just like if you work for someone and you have your job duties and you have an idea of what your job duties are worth. You're going to negotiate with your employer and say, I want a raise based upon A, B, and C. Your employer is going to come back to you and say, well, no, I don't think that you should get a raise. Primarily with immigration courts, with the backlog that's there. So there's a lot of things that could, a lot of variables at the moment, and there's a lot of moving pieces. And anytime you have such a large bill like this, you're going to have key negotiated topics, and things are going to be added and omitted as these talks go along.
Okay. Yeah. Thank you, Lucas. So on this new bill, just I'm adding one more point. We got one question from Shivani. Any provision for medical student on F1 visa and new immigration bills? Just we discussed about the STEM and STEM doctoral, some exemption for the green card. They can, as numeric limitation.
Yeah, you have a self-petition in certain circumstances. And as far as, what degrees would be covered and the process for that, that's still something that has to be, brought out. But, the key concept, I think, and if we're looking at everything and talking about just concepts and not actual procedure at this point, or what the actual details are, if you think about this, the concept that's addressed, it's very promising, is the United States wants to attract people who are professionals, who are high-end, either researchers or doctors or computer scientists or something like this, and we want to make it easy for that person to come here and obtain a green card or become a citizen and stay here. Okay, so that's going back to the core tenet of what we've been talking about, that we want to keep the best and brightest as a part of our immigration system, to where we can have these individuals contribute to our economy, or to science, or to research, or to whatever it is that keep the United States a world power. So if we're looking at the whole concept of what's being included in here, it's very promising. It opens the doors to make that process much easier for people in a similar situation, if that makes sense.
Okay. So let's come to regular topic on H1 Cap 2022. Do you have any further updates on upcoming application process?
Well, I'm glad you brought that up. I think we discussed that, a few weeks back, that President Biden and the administration has gone ahead and suspended the rule change that, we've discussed about pretty much how you have to, be selected at whoever has the highest wage level and then go down from there. And they kind of did away with the random lottery. So that was postponed this year, which is good news. So the lottery system, registration system is going to work the same as it did last year. And, it was a pretty smooth process. It did help mitigate any errors or mistakes that are made when you're preparing thousands of applications at one time, or petitions. And so in this process, it's the same as last year, where we need the name, date of birth, passport number, if you're a master's degree or not, what country you're a citizen of, what country is you're born in, your nationality, and things like that. And then you'll be selected, to file your H1 case, at a certain time. So the cap, or the registration period, opens on March 9th. I believe it concludes on the 20th, I think.
March 9th to March 25th.
Yes, and then by the 31st, USCIS plans on notifying people who've been selected. So we offered it. That allows us to pretty much automatically import the data from our spreadsheet into the USCIS portal. We have that employer, whoever wants to petition, we're not charging registration process, and the employer fee that they would at the registration period is just a $10 registration fee. And of course, once the cases are selected, if you choose to file, then those fees, we would charge our fees at that time if that was the case. But we're trying to help make things easier. Last year, not directly from what my knowledge is, but I've heard from other people where cases were accidentally filed twice. If you file two people in the same company, like the same person, if you file them twice within the same company, the case is going to be denied for both, and it's automatic this time. So there's some cases last year I heard from other people where, maybe the HR or other people, they'll add 5 people every day and the lists get confused, or things like this, and accidents happen. So we have, a tool that helps mitigate that error, where it automatically checks to make sure there's duplicates or not, and what's been filed or not.
Let's say you discussed about the duplicates, right? I am about to ask this question. Let's say one person have the 2 offers. He want to utilize maybe both. Let's say he applied and it got a duplicate. What is the consequences for him? Is any issue potentially in future?
No, it just limits it restricts you from filing that year with that company. So when we're talking about duplicates, what we mean to say is company A files for me on March 10th. Then on March 15th, company A mistakenly files again for me. And the system, which obviously is it's more of an automated process. It's gonna find those duplicates, because if my passport number is gonna be the same, my date of birth is gonna be the same, my name's probably gonna be the same, and then it will omit me from that company. So if I also have an offer from company B, that won't impact me in the sense that for being able to file with that company. It's just company A being able to petition for me when there's a duplicate. So I know a lot of prospective employees or OPTs, CPTs with. So that happened last year, and this year I'm sure that they'll have multiple job offers again this year. It won't impact as far as being denied as having a duplicate petition.
Okay. So if anyone want to apply, still we have date for March 25th to 11 a.m. Central EST time, right?
Eastern time, correct.
Eastern time. Okay. So let's come to 485 adjustment of status updates. Do you have any information about the biometric receipts? Still, most of the people did not get the biometrics. Do you see any progress on that one? Or
we've been seeing a few biometrics come in here and there. You just have to remember that this is a FIFO system, first in, first out. So if you live in a large metropolitan area where there's a lot of immigrants utilizing the biometric service, the line is going to be longer. If you live in an area of the country where there's not so many immigrants utilizing that service, the line is going to be much shorter. So the most important point I can bring up on this subject is if you receive the notice and for whatever reason you're not able to attend the appointment, it's very easy. You can check a box about the middle of the page on your biometrics appointment, mail the notice back in to the address listed there. And I think it's in Virginia, right outside of Washington, D.C. And your biometrics appointment will be rescheduled. And then you should receive an updated appointment in the mail. Again, it's a first in, first out system. So if you reschedule your appointment, you're just moving back in line. And as far as, that goes, it's just a matter of, certain metropolitan areas like Houston, Dallas, Los Angeles, New York, New Jersey area. All these areas have high density of immigrant populations. So the need for biometrics is greater than if you're in like Omaha, Nebraska or Denver, Colorado. So it's just really a function of where you live as far as how fast you could get the appointment.
Okay. Now we are discussing 485 adjustment of status. I have a question from Shivani. If after downgrade EB to EB3, maybe once we get the I-140 receipt, do you recommend to upgrade the premium process?
Well, that's a good point. And I think we've discussed this before to other people. It depends on your personal situation, Shivani. If you feel that you need to have the flexibility to be able to freely transfer your petition from one employer to another, then I would say, yes, go ahead and upgrade your I-140. And, once it's approved, after 6 months, your employer cannot withdraw it. So then that means after the 6-month period, if you wanted to go from employer A to employer B, all employer B would have to do is, sign a supplement J whenever it comes time for your adjustment to be adjudicated. And that allows you to freely port your application without having to worry about refiling your perm or another I-140. If you have a really good relationship with your employer and there's no real concern about that, then there's no real benefit to go ahead and having that I-140 approved because we don't. It's not going to speed up the adjudication of your adjustment. Your adjustment's not going to be processed until the final action date becomes current for your visa category. So if you downgrade to EB3, I think right now it's January of 2010 is the final action date. So you can imagine if your priority date is let's say June of 2013, there's still about a 3-year gap between those two dates. So it's really, you'd have to, a case by case basis, you'd want to analyze this, what's going to be best for you and your family, and reach out and discuss this with your attorney or with your employer if you feel comfortable to do so. And what you really want to do is make sure you just have security, because we discussed in the first part of the show about how this is great news with this new comprehensive immigration reform bill. But at the same time, you also want to plan. So if you need to move or port to another employer, you're free to do so.
Okay. Lucas, I'm adding 2 questions from Shivani, follow-up question. She is asking about the age-out scenario, referring the first question, and I think look like her final action date is current.
Okay, good. So if the final action date is current, I'd have to know more information as far as how old the person's your child is to know about the age-out scenario. But if your final action date is current, that means I would go ahead and probably file in premium and get this moving. So as soon as the I-140 is approved, hopefully you'd be called in for an appointment or for an interview, and that way you can go ahead and have this finalized as soon as possible. Another few things you can do after the I-140 is approved, I would also reach out to your local representative, maybe state senators, and let them know, can you help inquire with USCIS about processing your case faster? They have, all elected officials in Congress have liaison office members to help coordinate with USCIS. So, we don't want your date to retrogress at all, because that means at that point in time, your adjustment of status would, stop being processed.
Okay. So what is the CSPA applying? It means, I think she is trying to apply in CSPA processor.
CSP, consular?
CSPA. The Shivani, we are not clear on this one. Maybe you can elaborate it so we can address that one. So
is she in India, I guess?
Shivani, you can respond that one. Are you currently, are you in India, or you are asking behalf of any? Yeah, you can post your question. Maybe you can reach out to info@bgimlaw.com for more information. Thank you. Lucas, here I would like to discuss about the children age out. Very interesting point. It was the before discussion or before question. Let's say if the current date pre-added date is current, they downgraded to EB2, EB3. They are waiting for the I-140 approved. Here, the scenario is when the final action date is current, by default, child age is locked out, or we need to wait until I-140 approved?
So the I-140 has to be approved, okay, for the adjustment of status to proceed. Now you're concurrently filing, but for the adjustment to be properly adjudicated, you have to have the I-140 approved. That's number one. Number two, as far as the age-out provision, we have certain protocols in place to help mitigate that under the Child Protection Status Act and things like this, to help recapture time lost to adjudication delays. But it's very narrow in scope and function. The proposed changes, like what you mentioned, would incorporate maybe freezing the child's age at the time of filing. So if it takes 2 years to process, what we're saying is if the kid is 16 or 17 whenever we start the process, depending on however many years it takes to get to the finish line, that we don't let the children age out. And that's the key provision in this that we want to make sure comes through, because, if that were to happen, then you have to the child's going to have to go through that process again for employment-based, or you're going to have to wait and file a family-based petition once you receive your green card. And then, under that visa category, it would impact decisions on how soon your child could get married, it would impact, how soon if you needed to become a citizen to sponsor them, and then still even if at that point it's still many years of waiting.
Okay. Shivani, I think we hope you got the information about your question. Lucas, I have one scenario. It's not a scenario, it's a question. I got a couple of inquiries about the H1 exemption cap. They initially they applied back in 2006 and 2007, but as we know, only the initial approved petition valid to 6 years to reapply or maybe reapply for new H1 process. Here the question is, if they want to apply for H1 with the cap exemption, will they apply?
Yes.
Will allowed to apply?
So this is a change about 2 years ago. In the past, let's say someone sponsored, you have an approved H1B petition, but you never arrived in the United States. So you've never used any of the 6 years allotted in that visa. Well, the policy used to be you had to, utilize that visa, and after a certain amount of time that the visa is no longer valid, you would have to go back through the lottery. An amendment was made and provisions were changed now that if you have an older H1B, you can now, once you're cap exempt until you utilize the full 6 years of that visa. And then, hopefully once you're here within that 6 year period, you can go ahead and have your I-140 approved. So you're pretty much remaining cap exempt indefinitely.
Okay. If they want to apply, they can apply, right? Even though they utilize for the 1 year remaining, they can apply for the 5 years, right?
Correct.
Beyond 6 years.
We would want to make sure we say that this is, probably case by case basis. You don't want to make sure that, your initial petitioning employer didn't have any issues where your petition was revoked for any reason, because if that was the case, like if it's revoked for fraud or anything else, that still means you have to go back through the cap. So there's certain circumstances, to this. So you want to make sure you consult with your attorney or employer before you just blindly, try and file for cap exemption status. But yeah, if everything was normal and the petition was just dormant, you absolutely recapture that unused period.
Okay. So let's come back to 485 adjustment of status. We know most payments, 485 got rejected due to some reason, not filling properly, and some other reason. If they want to, we know that the current application date is not a filing date. It's went back to final action date. So if they want to reapply, USCIS is considering to take application for 485 adjustment of status.
Well, we discussed that a couple of weeks ago, how I think there was a liaison working with USCIS about that due to the number of cases filed and how long it took to receive a rejection, or maybe if the rejection was due to the monetary instrument becoming stale. And we're still pending, news about that. But yes, I would expect that the filing dates become current again as far as, what was there, it's easy to resubmit. But I actually think, here within a week or two, we'll have news about resubmission to the service center. So I don't think that that's going to be an issue at all.
Okay. So let's discuss on the March Visa Bulletin. Mm-hmm. So we observed EB2 and EB3 move to the 3 months.
Correct. It moves so quick.
Quick, yeah. So can we expect in future will move forward? Or?
I think this year, anything's possible, because you remember, in part, we had this presidential proclamation we started our show with tonight that was limiting the number of green cards coming into our country. So that benefited us both in filing last fall, and also for people who have been waiting for a long time to get, I had one client of mine, she and her husband were waiting, I think 2.5 years, and their priority date was May 2009. And it was just waiting and waiting and waiting. And now it went all the way past May 2009, all the way up to 2010, pretty much, within a short period of time. So, I think we'll continue seeing this trend throughout the remaining part of this year. And hopefully, now remember, I want everyone to remember, whenever we're talking about the comprehensive immigration reform, the two bills, one in the House, one in the Senate, as soon as that's signed into law, whatever date that might be, usually there's a 180-day provision for implementation, which means we have to wait 6 months for those policies to really be implemented. So, I think we'll still see, a lot of movement on the Visa Bulletin, but at the same time, I think once this becomes law, we'll continue seeing that trend, and maybe the dates will move even faster this time next year.
Okay. Thank you. We hope we discuss all topics today. Lucas, before ending the show, do you have any additional information to share to our listeners and viewers?
Yes, I do want to bring up a point you and I discussed 2 weeks ago, Venkat, that I really encourage anyone who's watching the show who might benefit from this, or who know people who might benefit from this, reach out to your local representative in Congress, reach out to your local senators, let them know how important this is to move forward. Let them know how it could impact everyone's life. And, really that's what keeps the wheels moving, is the more communication that these representatives have from their constituents or people who live in their districts. That's what really gets this legislation moving. Also, I urge everyone to reach out to, maybe other non-profit organizations, like we have the Telugu Association of America that's in Virginia. Reach out to them, see what they can do to help. We have AILA, American Immigration Lawyers Association, that we have our days of action for. We also reach out to our representatives and senators. So it's very important to not feel like you can't communicate because you're not a citizen or a legal permanent resident, or something could happen. It's very important to communicate and let people know how important this is, and that's the real motivation and the driving force for change.
Okay. Lucas, last one question. We got one question from Naru. He applied the H1 extension. His H1 extension is progress, but his passport expiring October 30th this year. His question is, will approve only H1 till October 30, or how does it work while expiring a passport?
Everything should be fine as far as like a normal approval for the extension. The only time we really have that issue, I think, is when it's less than 6 months.
6 months. 6 months.
The passport, whenever the passport's expiring, I think that's usually when we see issues with that, because the USCIS is going to issue an extension on your I-94, and that comes in the form of the I-797A. The approval notice. So, go ahead, and you need to initiate the process anyway to get the, passport renewed. If anything does come up from that, you can always go for stamping and re-enter, and you'll have a fresh I-94.
Okay. Yeah. Thanks, Lucas. Thanks for today webinar.
Thank you, Venkat.
Yeah. Thank you very much. Viewers, we are every week we keep saying this is only the information session. Don't consider this as the final. Maybe you don't take as a final action of this webinar, just we are trying to educate to our community, and we are trying to give them more information on immigration, complicated immigration system. Just to take information what is required for you, and you can discuss it with your lawyer, maybe your employer. Based on that, you can take the right direction as per your scenario. So we continue to this the weekly webinar on every Wednesday 6 p.m. Central Time. Keep watching, and thank you very much each and everyone who participated and who watching this live show. Thank you. You can post your question on Facebook, Telugu NRI Radio, or Burgos Garritson Law Facebook, or if you want to talk to privately, you can send an email to info@bgimmlaw.com. Lucas will respond your questions, any topics. You can participate every week, and you can call on conference number if you want to talk to directly Lucas. Always welcome to join the conference call, and every Wednesday 6 p.m. Central Time. So we keep trying to provide more information, updated information, and thank you each and everyone participate today. Thank you, Lucas. Thanks for having with Telugu NRI Radio. Bye. Until next week, next Wednesday, same time and same platform. Thank you. Bye-bye.